that ID plays is the role that the initial crafters of
right now there are a lot of things. For example, there's people cannot see this podcast. This we cannot keep because they're copyrighted.
yeah.
Imagine it doing public domain.
The Institute Librarian, Professor Ayo Bokurocha, the Institute Secretary, Mr. Tiami Ademola, the Director of General Administration, Mrs. Nancy Jerry Imayani. We recognize the presence of all the professors, directors of in Nigerian Institute of Advanced Legal Studies, Nigerian Copyright Commission, and Free Knowledge Africa present. We recognize the presence of our facilitators present as well. We welcome you all once again. As you all know, we are celebrating the World Intellectual Property and Public Domain Day, themed Intellectual Property and the SDGs, building our common future with innovation and creativity. From the program of events, we have the remarks by the DG NIAS, DG NC, and representatives of the Free Knowledge Africa. A round of applause as we welcome the CP Niles for his opening remarks.
Sorry, ma'am.
Let's do now. Am I being heard now?
Yes, you can hear now.
Okay. I have actually said that I was going to stand on the protocol that you have established as the main of this program, or the main partner of this program. My DG of the Nigerian Institute of Advanced Legal Studies, and the partners at Free Knowledge Africa. The Nigerian Corporate Commission is delighted to be able to collaborate and partner with you on this webinar. You will pardon me because the first thing that struck me when I received the invitation was the confusion as to whether I was going to be speaking concerning the World IP Day or the World Public Domain Day. I'm aware that Public Domain Day is usually 1st of January, which is the day that most works in the copyright sector go to public domain. So you pardon me if I spend more time just a few words on the World IP Day, and the theme for this service is IP and the SDGs. It's about how we can build our common future using innovation and creativity. But interestingly, the choice of the celebration as the organizers have placed it, intellectual property / public domain, immediately points to the often conflicting positions of intellectual property and the concept of public domain or free knowledge. Much as these issues evoke all kinds of sentiments, it's important that for us to build a common future, for us to use innovation and creativity in the most sustainable manner, there must be a balance. And the Nigerian Corporate Commission is jointly engaged to work with other stakeholders and partners to see how we can continuously improve on the plans, make knowledge more easily accessible, make quality knowledge accessible to Africans, in order to ensure that we meet the SDGs that we have for ourselves. For the Nigerian Commission, we are not interested in goals number 1, 4, 5, 8, and 9. We believe that using the copyright system in a sustainable manner, we can decrease poverty. And I also believe that the use of the copyright system should help us to raise the quality of education and make quality education available to our children. Not only to the sighted, but also to the blind, the visually impaired, and those who are otherwise disabled. These are some of the concerns that inform the new Copyright Act 2022. And the Nigerian Copyright Commission is committed to ensuring that every provision, every exception, and every facility available under that act will be used to improve on the copyright system and to build our creative industry for the good of the Nigerian economy and for the betterment of humanity. While we reflect on the theme of this year's World IP Day, and we also look at the future threats to the copyright system and indeed the non-fledged ecosystem. There are present access issues that experts are debating, and of course there are the new disruptive technologies that are already confronting us. The big one is artificial intelligence, and I'm sure that as experts and stakeholders, we should be able to find some thoughts on how we're going to confront the issues already with us and begin to prepare for the ones that are beckoning. Incidentally, in the IT world, it's often said that free is frightening. And anytime we talk about free knowledge, it frightens most intellectual property experts. But I'm sure that the experts here today will be able to give us a balanced view of how we can, on the one hand, protect intellectual property, and on the other hand, make knowledge available in a way that we can together do the SDGs that today is celebrating. Thank you very much. Thank you, DJ. Those are my remarks.
Thank you, DJ sir.
Thank you very much, Dr. John. I came from Geographical Policy. Officer Tor and Dr. Eileen, please take over.
Thank you, sir. So we would like to recognize the representative of Free Knowledge Africa for your opening remarks.
Good morning, everyone. Can we, it's a privilege to... Good morning, everyone. It's a privilege to be here, and we appreciate the Nigerian Institute of Advanced Legal Studies, the Nigerian Copyright Commission. We thank them for this opportunity to collaborate with them and to share our views. So first, I would like to say that intellectual property and the public domain, they actually go hand in hand. And I believe this is not the opinion of the organization, it's the opinion of myself that we should be celebrated together. Because intellectual property leads to public domain, whether we like it or not. It is a go hand in hand, and for these two to coexist, you have to start having conversations about it, and that is the essence and the purpose of this event. The public domain just refers to items. The public domain refers to items in which the copyright has expired. And for something to use its copyright, it must first have, for a creative work to use its copyright and be in the public domain, there are so many intricacies involved in it, and we want to educate the public about these intricacies. So I welcome everyone to this journey of learning and how we can evolve our future and how we can create a better future through innovation and creativity. By assessing works in the public domain, we can propel more innovative works in our future, and we can also teach the creators about how to maximize their intellectual property through copyright. So thank you everyone for joining us wherever in the world you are. We appreciate you, and we expect you to have a wonderful learning session. Thank you.
Ask those guys.
Good morning, everybody. Thank you, Mr. Alakia, for that. So, my name is Hope, and I am the co-host for this event. So, we'll be going on to the next thing for today's event. We're calling on our best set of speakers for this event. So, the first person that will be speaking to us today is Professor Adimabo Adewopo-San. Please come space bio. Can we please display bio?
It's bio.
Professor Adebamo Adewopo is an intellectual property law specialist. He served as Director General of the Nigerian Copyright Commission from 2004 to 2010. He is currently a professor at the Nigerian Institute of Advanced Legal Studies. Adewopo obtained his LLB honors from the University of Maiduguri, Nigeria, and his postgraduate degrees from the University of Lagos and the Franklin Pierce Law Center, University of New Hampshire. He has taught IP at Lagos State University at both undergraduate and postgraduate levels, and has held visiting researcher positions at the Max Planck Institute in Munich, 2003, and the Center for Research in Intellectual Property and Information Technology, University of Edinburgh, 2005. So please, with an ovation, can we please welcome Professor Adebamo Adewopo. Hello everyone. I want to stand on this. Please, I will like to step into the shoes of Professor Adewopo to do this presentation, because at the very last minute, had faced circumstances with young stroke, so I noticed that he's not here able to take the presentation. But I'm quite happy about the presentation, and he also sent me a copy. So I'll take his presentation on this camera. So this is the first presentation for today, and naturally it's supposed to set the discussions that will follow. And it's titled Intellectual Property and the Sustainable Development Goals, which henceforth are referred to as SDGs, building our common future with innovation. Okay, now it's based on the overall theme for this day, but the specific topic of Professor Adewopo's presentation is intellectual property as a catalyst for achieving SDGs. So this presentation is structured on 4 parts: rapid introduction, we also discussed the nexus between intellectual property rights and the SDGs, and then we also discussed the IP as a catalyst for the SDGs, and then we have the conclusion. So the legacy of the World Intellectual Property Day has never ceased to impress on global consciousness. A profound theme that always affirms the benevolent of creativity and innovation to mankind. Since its inception in the year 2000, when WIPO first instituted April 26 as World Intellectual Property Day to raise awareness about the significance of intellectual property, each theme has faithfully defined the timeless role of creators, innovators, and inventors in the flourishing of society. This year's theme, Intellectual Property and Sustainable Development Goals, SDGs, building our common future with innovation and creativity, shines a light on the central importance of innovation, creativity, and intellectual property to achieving 17 SDGs. Innovation as our common feature because the complex dynamics of intellectual property and SDGs in a world that is faced with multiple crises as the 2030 deadline to achieving the UN SDGs draws closer and closer. The theme reminds us of the collective debt, unliquidated burden of peace and prosperity for people and the planet, and the role of innovation, creativity, and intellectual property in the liquidation of that burden. WIPO's theme underscores the central role of intellectual property as a strategic tool in facilitating the SDGs realization for the benefit of everyone, without leaving anyone behind. It finds currency in the tensions of the fundamental objectives and narratives of intellectual property policies and SDGs with impact on our common future. So now this underscores a kind of connection between intellectual property SDGs. So the next section basically expands on that connectivity. What is the nexus between intellectual property and SDGs? The first impression of the relationship between intellectual property and SDGs goes to the root of the fundamental purpose and mechanism of two phenomena. This impression lies in the protection mechanism of intellectual property as an incentive to creativity and innovation, as well as the contribution of creativity and innovation to the flourishing of society. In rewarding the efforts of creators and inventors, and at the same time enabling the public to access their work, IP connects with the common goal of sustainable development by finding solutions to social, economic, health, and environmental challenges that face global society, thereby sharing a common thinking to the SDGs and building a common future of humanity. The UN 2030 Agenda for Sustainable Development is a plan of action for people, planet, and prosperity. At the heart of the agenda are 17 SDGs, which cover wide-ranging themes, carefully organized into 5 thematics: importance of people, planet, prosperity, peace, and partnership. These themes include fighting poverty, good health and well-being, quality education, gender equality, affordable and clean energy, decent work and economic growth, industry, innovation, and infrastructure, climate action, peace, justice, strong institutions, among others. Now, these are all clusters in and numbered from number 1 to number 17. Since 2015, when the job started ticking, this Sustainable Development Agenda was both ambitious and onerous. To accomplish such a brave mission in 15 years in an already fractured world faced with challenges of technology. Nonetheless, it is attainable within robust cooperation at national and international levels. The SDGs have engendered complex geopolitical debates on the implications of national and international policies and agreements on the global goals, with each SDG requiring specific policy initiatives. Basically, the whole idea of sustainable development has been a subject of conversation and development experts for decades. And it seems we are in a constant state of reconstructing the idea and its intrinsic value right from Brundtland Group to SDGs as we have it today. The world has continued to witness the immense value of innovation and in providing solutions to diverse social problems such as health, education, climate and energy crisis, agriculture, food security, human rights, livelihood, and economy, and more. Yet, the recurring intersection of the intellectual property system and SDG have raised several questions, particularly on how the constant evolution of IP norms challenges the SDG landscape and whether new and dynamic approaches to IP policy making can and will deliver on development aspirations and SDGs. Questions about whether the IP system will require dynamic shifts in the operative norms to adequately engage SDGs exigencies in a world experiencing enormous inequality. And we can see that inequality both in the access to technology, access to education, the digital divide between the global south and the global north. So in that kind of ecosystem, how do we want to integrate intellectual property in order to give birth to sustainable development? So that is basically the question that is raised. So in developing countries, for instance, access to knowledge concerns have continued to question the global commitment to balance the IP system and the realization of the SDGs. One can cite access to knowledge, education to students, unfinished business, with access to medicine and vaccines, and public health questions in a post-pandemic world as we saw during the COVID-19 pandemic. And we can recall the wrote about vaccine nationalism, where other countries were calling vaccines for their people, and countries like South Africa that were largely used by the pandemic were not able to access vaccines. South Africa had the capacity to do this vaccine, they didn't have the money. So that's the kind of example of the kind of gaps that we have to also factor in. Now, IP as a company, so how does the intellectual property now facilitate the achievement of the SDGs? That's what the next section is kind of explain. So as the IP system provides the primary legal and policy framework for protection and for the promotion and protection of creativity and innovation as well as legal rights over them, SDGs encapsulate a broad range of global goals for sustainable development and are seen as the ultimate blueprint for the sustainability of human society. IP therefore can be regarded as a catalyst for achieving the SDGs, and this can be achieved through the implementality of four key mechanisms. What are those mechanisms? First, among them, the mechanism of intellectual property legal framework. Now, how does that framework serve as a catalyst? IP law is the framework for protecting intellectual property to achieve all the objectives of promoting innovation and creativity that are essential to the SDGs. For instance, generally, copyright law, and in particular, if you refer to our own copyright law, 2022, the Copyright Act, copyright provides legal framework for the grant of exclusive economic and moral rights, administration of intellectual property rights, enforcement of rights, including provisions of limitations and exceptions in Section 22 of that Act. As an integral part of the IP framework, limitations and exceptions are very vital IP instruments for achieving the SDGs because of their role in fostering access to creative work and maintaining good public good, particularly under copyright and patent law. Under copyright law, for instance, general exceptions are provided by way of fair dealings for purposes such as private use, non-commercial research, and private study, criticism, review, or reporting of current events, among others. It includes special exceptions for blind, visually impaired, or otherwise print disabled persons under Section 26, and special provisions for those institutions to be referred as GLAM, galleries, libraries, archives, and museums, among others. Now, these provisions help to provide access to knowledge, access to education, access to technology. So when you have those limitations, what it means is that any user falls under those limitations, the public is free to use, to make use of that work to whatever purpose that they want to. So that kind of facilitates access to knowledge, access to education. You have things like open access, open education resources. You have open access publishing, which publishes open access journal. So with those kind of provisions, it helps to facilitate access to work. Now, in the area of technology and patent law, for instance, provisions relating to non-patentable inventions in Section 1 of the Nigerian Patents and Design Act and compulsory license regime provide an important patent instrument for access to patent inventions for public health and public interest, thereby helping to achieve the SDGs. Under Section 1(4) of the Patent Act, patents are not accepted for certain knowledge such as essentially biological processes of production of plants and animals. So essentially, it allows anybody to key into these inventions to produce other inventions for the use of the society, especially in areas in medicine and cultural biotechnology. Now, White House Initiative, that's the second mechanism. This is another IP mechanism that has proved useful for achieving the SDGs. Substantially, this involves White House non-setting activities. White House fidelity to the vision of the government is evident both in its founding and its history. Prior to the Sustainable Development Agenda itself, White House had launched the White House Development Agenda in 2004-2007 and established a development program focusing on global challenges in the area of health, security, and climate change. Even long before the development agenda, and indeed in the annals of IP non-setting, successive instruments from both the Paris and then Convention up to the the more recent WIPO treaties, they have been the current decimal, the WIPO's institutional template. Now, it is instructive to this year's date that 2 more treaties are expected this year, as WIPO holds 2 landmark diplomatic conferences that will further shape the digital security and protection and advance the use of the SDGs and our common future. And this one of them is the Design Law Treaty. WIPO, as the focal UN agency for the promotion of IP law, has developed an array of programs that are important contributions to the SDGs. This covers a wide range of programs that provide technical assistance and information and support creating online marketplace for technology license. Some examples are like WIPO Brain, WIPO Accessible Books Consortium, and so many others. The next one is international cooperation, and this is the third aspect that involves international cooperation between WIPO as a local UN agency of IT and UN itself. WIPO's membership of the UN Sustainable Development Goals is a testament to its commitment to Agenda 2030. This cooperation also includes engagement with other UN global agencies such as the World Health Organization, UNESCO, International Labour Organization, World Trade Organization, and also in that regard, WIPO maintains a history of cooperation and partnership with its members on various IP law and policy activities, both directly and through external offices. And finally, national and regional initiatives. And this is a vital instrument for achieving the SDGs. And it involves national and regional initiatives. In the SDGs, we have found a global consensus on the common future that is being shaped not only by diversity of global, but also by local policy making. National and regional initiatives are seen in the wave of IP law and policy reform across regions and WIPO leadership, and which are increasingly enhancing the scope of IP's contribution to national economy through protecting and advancing access to creative and innovative tools that have continued to help improve the standard of living in those countries. The various sub-regional regimes for protection of indigenous communities, health and diversity, IP, human rights, and public health are important reference points. Africa's complex human regimes have increasingly featured IP as a strategic tool for development. Agenda 2063 reflects SDGs in Africa's aspirations for inclusive and sustainable development, and taking alongside African free trade agreement along with its IP protocol. So these initiatives align with IPO's vision of our common future through the instrumentality of innovation, creativity, and IP integrated in current field. Recent legislative and policy reforms provide new companions to the SDGs. On the legislative front, there are 3 new laws in Nigeria, specifically the Copyright Act of 2022, the Plant Varieties Protection Act of 2021, and the 2022 Amendment to the Trademarks Act, which are contributing to expanding the compass of promoting and protecting creativity and access to knowledge, promoting food security and agricultural innovation, and promoting trade facilitation and ease of doing business. The objectives and substantive tenure of these laws have wider implications and linkage a good number of the SDGs. And of course, as we listen to the presentation, we begin to see how those connections are unfolding. So on the policy space, the draft national IP policy and strategy, the institutionalization of the creative economy as a government ministry, and the anticipated capitalization of IP administration in the context of the long-standing implementation of 2014 white paper on the nationalization of government agencies and pivotal initiatives to mainstream IP for national development policy implementation. Singular and combined impact of policy, legal and institutional reforms are the impulses that are further advancing the dynamics of aligning IP and the SDGs in the country. So finally, in conclusion, it says, mindful that the task of managing health has always been man's body and his ingenuity from time immemorial. But as humanity trudges along the limits of the digital frontier, the global community has not relented in aspiration for a future that creates that's creativity and innovation of its citizens and in general. Now, with the past 12% of SDGs achieved, a suboptimal milestone in a post-pandemic era characterized by war, poverty, inequality, hunger, migration, climate crisis, and other crises are on call to accelerate SDGs milestone and revamp the broken global economy. This is how momentous the theme of this year's World Intellectual Property Day is, and it compels greater attention to the knowledge governance system to implement pro-development and balanced framework that will help to achieve the sustainability that is so direly needed in this turbulent time we live in. Thank you very much.
Can we applaud Assistant Professor Electrical again? Please, can we do that better? Professor, I want to apologize to everyone, both virtually and physically, for the technical issues. We are very sorry. So moving on, we'll be going on to our next speaker that will be speaking to us virtually. We'll be going on to introduce Dr. Ifeoluwa Olubi, Associate Professor at Babalola University at Ekiti. She'll be speaking to us on the public domain and the SDGs, leveraging the public domain for creativity and innovation under Nigerian law. So please, with an applause, let us please welcome Dr. Ifeoluwa Olubi.
There are quite a number of works that are falling into public domain based on projects by Privilege Africa as well as this Wikipedia project. But I just picked some of them, maybe because I think I'm familiar with it or some other. For instance, Shakara, that person. Thank you. Alright, so for example, Shakara Bakanapiti, I remember this, hearing that at least on the radio waves and my parents when I was younger, Shaman Miki by Ebenezer Obi. So many actually. Some of them are sound recordings, some of them are photographs, some of them are broadcasts, like the announcement of Nigeria's independence, the broadcast work, image of Sam Ebibino, that's an artistic work. And that is a good grammar of Yoruba language by Bishop Samuel Ajayi Powder. So, you know, for sound recordings, broadcasts, artistic, photographs, right? And audiovisual work, the term is 50 years, so 50 years after they were first published or made or broadcast. So I think that's what made that category. to already enter the public domain. But that has quite a lot, but there are over 500 listed there. I just keep a few for us to see. Okay, so I want us to see the public domain not as a network, not just as a dump site where we keep materials that are left, after everybody has seen the juicy part covered by intellectual property rights. It's not a dump site of what is left over. Rather, the public domain contains raw materials for new creations, innovation, and development. I think we need to do public domain that way. It contains building blocks for the enhancement of our creativity, and now relating it to SDGs. The first speaker, Professor Adogo, is talking a lot about public domain and SDGs. So I believe that it contains one of my various things we need to be able to attain the SDGs. So I have here some of the values, the importance of public domain, including enabling competitive innovation, enabling us to have follow on innovation, promoting education. We have low-cost access to information and knowledge, access to cultural heritage. We'll talk a bit about that. I know that the next speaker is going to also talk more about this. It promotes public health, safety, and amongst others. Now, very importantly, I'm really happy that our DGs are here, and the fact is that the public domain is shaped in laws by national laws. I appreciate Dr. Jonathan saying in the video of NCC when he talked that the Commission, through the laws, they are ready to ensure that every single exception or limitation that should be available freely is available. And I will give examples from the law as I go on in my presentation. So the fact is that how large or narrow the public domain is in every country, a lot is shaped by national laws, because the international legal regime pressure, some flexibility to the national levels to determine certain things like the specifics of eligible subject matter, excluded subject matter, limitations and exceptions, the term of protection. For instance, for copyrighted, the minimum required under the Berne Convention is the life of the author plus 50 years. Nigeria, we are doing plus 70 years. Some jurisdictions go as high as plus 90 years. So how soon a work enters the public domain, you see that it's shaped by national law. For instance, when we are determining what is going to be our term of protection, and there is also the validity of registered rights. We have seen sometimes the same facts are brought before the national courts, and that national jurisdiction will say, oh, the patent is valid, or the design is valid, and you go to another jurisdiction for various other reasons based on their laws and interpretation of the law, they will say it is not valid. So I think the national law has a lot to determine, to be able to tell us the contours or the extent, of the public domain. So I believe that policymakers and legislators in the country, depending on the policy objectives of that country, they have a lot to do in determining the extent of the public domain and how it can be used to attain the SDGs. Right, so let's give examples here. Some of the SDGs. Jordan has done a very good job. But for instance, if we talk of SDG 3, for good health and well-being, we see that the public domain contains information that help in the health sector. SDG 4, SDG 4 talks about quality education, democratization of quality education. SDG 4 talks about the democratization of information industry and creative content. You see that a lot of information we need for our quality education and decent work and economic growth. I'll talk briefly about these. There's a lot that people can do to earn from works in the public domain by commercializing it, and then it's going to also promote SDG 9, exploiting and building on the existing knowledge, for innovation and infrastructure. So I pick SDG 8 as an example. We have commercial publishers and broadcasters that are making money by making use of works already in the public domain. Then we also have creators that adapt to transform works in the public domain. And I have examples here like Dracula, a lot of children books are based on what's in the public domain. And we have the example of even raising funds, a crowdfunding fund or a Kickstarter, where to develop a 3D world where children can act out scenes from Jane Austen's novel. So these are some of the examples. And now, for instance, we know we have Creative Commons, open source software for the perpetual industry. And then WIPO also has this accessible book consortium that can help. So I talked earlier about determining the extent of the public domain. So you can have a shrinking public domain. For instance, in Ghana and Sierra Leone, there's the payment of a fee before people can have free access to the public domain. I think that is not really good. As much as the argument is that they are raising money for the creative industry, I believe that the public domain should be free, really free. If we are saying that we should have free access, then sometimes overlapping IP rights can try to shrink the public domain. In this case, it's an European case of Vigilant. Someone sought, or a company sought to trademark the protection of a popular artwork that was already in the public domain, and the court for public policy reasons rejected that, saying no, this artwork is supposed to be freely available in the public domain. Don't trademark it again, because when you trademark it then you get protection that can last almost forever. And we also have TPM. That's another threat to the public domain. You can use technological protection measures to protect them, even though they're supposed to be freely available. And that's why I complete the new Copyright Act that states that the anti-circumvention provisions for TPM would not affect the exercise of copyright exceptions. Alright, my time is almost up. I just want to talk a bit about talking about folklore cultural expressions in our public domain. Right? So people generally believe that this is a common heritage for everybody that should be freely available. But we know that various countries, because of exploitation, they have various sorts of hard laws that they use to protect us. We have that in our section 74 of the Copyright Act. But what you see is that based on that provision, people can still use these works to innovate and create. Illustration of an original work is allowed, creation of an original work, fair dealing in terms of private or domestic use, educational purposes, those are still encouraged. So I have the screenshots of some works, based on some of our folklore or folk stories, looking at some creative works that have been created based on them. So you see that once it's available in the public domain, it's really something we can continue to promote our creativity. So in all, in summary, I want the three major takeaways today. Number one is that we should begin to view public domain not as a job site or what is left over, but as a collection of raw materials and building blocks for our creativity and innovation. Also the role of our legislators, policymakers, the courts, the regulators in resisting incursions like we saw in England, where the court resisted an attempt to trademark something that was freely available in the society. And I think we can leverage a lot more on the provision in our laws about public policy, morality, and use that as useful ground to prevent unnecessary appropriation of public domains. In all, I think that we should all work towards promoting a rich and accessible public domain. Thank you very much for your attention. Thank you so much.
So much, Dr. Ifelwa. Thank you for that wonderful session.
What do you please?
Can you hear me, ma'am? Oh, thank you very much for that wonderful session. So we'll be moving on to the next one. And before we call on our next speaker, I just want us to look at that tables and now. The room is just very tense. So I want us to look at the one, just give them a very much you can introduce yourself to them if you don't know them. So just give your name a very warm smile. Oh, okay, so I'm really glad that most of the technical issues have been resolved, and I'm looking forward to us having a wonderful time together. So moving on, we'll be inviting our next speaker, Mrs. Ngozi Adebibibe. I'm sorry, I am not a Yoruba girl. I just apologize, ma'am. I'm very sorry, ma'am. So We'll be inviting her for the next session, and our bio is already displayed on the screen. She's a partner and head of IP practice at Jackson, Etsy, and Edo. Our expertise covers IP, privacy and data protection, patent protection, technology license, and brand protection. So with an applause, please, can we welcome on stage Ms. Ongwezi.
Good morning, everyone. The DGs present, the professors and associate professors in the house, distinguished ladies and gentlemen, I want to start on the existing protocol, and I'd like to start by thanking the organizers, NILES, FCC, and Free Knowledge for creating a forum like this to talk about IP as it relates to the SDGs. It's particularly important today being the World Intellectual Property Day. I have just a few minutes, and the topic I have been given is intellectual property, a catalyst for growth of the entertainment industry. I hope you can hear me well. Great. So I'm talking about IP as a catalyst for the growth of the entertainment industry. And you might wonder, because all the speakers, the keynote speaker and the previous speakers have spoken to the SDG goals very directly. You might wonder where this fits into the picture. Let me point your attention to SDG Goal 9, which talks about innovation and industry. And this is an industry that is important and pertinent to our economy today, and therefore, drawing the connection between intellectual property and entertainment industry is well in line with our theme for today. Let me start by defining, I hope I can give a clue to the person changing the slides. Yes. By defining what intellectual property is, I believe that everyone in the room and everyone online is familiar with the concept of intellectual property. But it does make for good conversation to start from some of the basics. The main reason why I want to point out the definition of intellectual property is because I want to highlight certain things. Michael describes IP as the unique value-adding creations of the human intellect that results from human ingenuity, creativity, and inventiveness. I feel like I have to pause here to say this. I'm not in the academia, right? I generally speak to business people, and so my presentation style will be very granular, right, and simple, because that's typically my audience. My clients are usually not. We don't understand the high sound. So I'm going to be very, very practical, very down to earth in how I talk about this subject. Two things are important to highlight there. Is the word human. Creativity is tied to a human ability to create. I mean, I don't want to go into the conversations around artificial intelligence and all the things that is bringing on board, but we do know that at the heart of our humanity is our ability to create. And that's what intellectual property seeks to protect. There's another definition here for IP laws, and I have been deliberate to separate this, and I will explain why in subsequent slides. IP laws, intellectual property laws, are the sets of laws that recognize and protect products of the human intellect, again, by granting to inventors and creators a legal right to exclusive control, to the exclusive control of their creation. How does this connect to the entertainment industry? The fact that creativity is a human ability, and that ability is most evident within the entertainment space. In fact, if you think about the meaning of entertainment, it's simply the ability to engage people, right? Whether you're giving them something printed or it's a film or a song, the entertainment business is really about providing people with something interesting to watch. And you wouldn't doubt that to do that, you have to be creative. You have to engage your ability as a human being to create. And that's speaks very directly to what intellectual property focuses on. The entertainment industry it encompasses several parts. And I don't even I wouldn't pretend that this is exhaustive. This is in no way exhaustive. But what I have done here is to highlight the segments of the entertainment industry so that as I speak through the connection between IP and entertainment industry, we can in our mind begin to make those connections to these specific segments. But let me say that by far the most affluent segment of the entertainment industry that most of us would relate with, if I were to ask people, that I'm sure I will get someone to tell me about music, about film, right? Some talk about theater, but I would dwell more on music and film because they are the most evident in our world today. Now, what is the connection? Where does IP fit into all of this? The first thing I'd like to say is that without intellectual property, we wouldn't have an entertainment industry. And that is so true. Intellectual property is intangible. It doesn't exist, except that the law says it exists. And if you think about it, there are some expressions of human creativity that the law doesn't protect as intellectual property. And so you cannot, you must have other ways of dealing with them in the way that is different from the way you would deal with intellectual property rights. So the point I make here is that IP is intangible. It exists only because the law says it exists. We all want to, if we wanted to say, oh, reading a book amounts to infringement, but does it? No, it doesn't, because the law doesn't recognize that act as one of the economic rights. You can't prevent people from accessing what you have written. You can prevent them from reproducing, you can prevent them from adapting, but the law is the frame within which we must consider intellectual property. It then means that when you think about the entertainment industry, the question is, how does intellectual property engender growth in that industry? What I've done here is to try to tie up some things very quickly. Creatives are happy to create, whether they realize that they can make economic gain from it. Most creatives are just happy to create. And so for a very long time in our history, in the entertainment industry, we had creatives who were just focused on enjoying the art of creating, and we're not thinking about converting what they created into tangible wealth, at least maximizing that. So every creative makes a creative output, a song, a film, whatever it is, a poem, and then IP laws step in to provide protection for that work. And in doing that, IP laws grant exclusive rights to the creatives. That exclusive right is the hinge upon every other thing. It's the hinge upon which the entire creative industry rests. Because it's by reason of that exclusive right that creatives are able to exchange or to get value from the public or third parties who want access to the works of their creativity. And so the IP laws enable profitability. They create an exchange, a means of exchange for the creatives. And when you begin to have pockets of that happening, you then have an ecosystem develop. Because where there is money, things begin to, other businesses begin to become interesting, and there's some interconnection between the businesses. I'll give you an example. If you think about the film industry has expanded incredibly in the past 10 years, and that's because there is more resources, and so the value chain is longer. There are more business models that have been built, and these things are happening only because intellectual property right has enabled profitability, and creatives have been able to engage that profitability to create an ecosystem. And that ecosystem is what eventually becomes an industry. Now think about it. If we did not have intellectual property rights, and I am a singer, And I sing like Asha. You hear me sing and you love where I sing. When I perform, you can capture my performance. You can replicate it. You can do anything you want to do with it and it would not be wrong. Asha will have no basis to create profit from her intellectual property rights. Think about the film industry. For years, that industry has grappled with piracy and crippled it. I mean, we're at a phase where we're seeing digitization has mitigated the painful effect of piracy. But for many years, even though Nollywood was churning up numbers, Nollywood wasn't necessarily making was churning up films, wasn't necessarily making the numbers. As at 2000, early 2000, I think it was, early 2000, Nollywood became the number 2 producer of films globally, surpassing Hollywood and only being next to Bollywood. But you and I know that as at 2000, Nollywood was not breaking in significant profit. So it's not just the numbers, it's what happens with intellectual property. And in that case, because piracy and all the issues around a poor intellectual property enforcement regime meant that there was little control over the creator's ability to get economic benefit from their work. It meant that there was a lot of activity, but you could hardly say that an industry was being formed. And I have to pause here to acknowledge the Copyright Act 2022. It's one of the most exciting things that's happened in the entertainment industry. An act that has very clearly made provisions to tackle piracy in a way that we haven't seen before, by providing enforcement mechanisms that are outside the courts. Because before now you always had to go to court. Now we have takedown provisions that enable, it engenders confidence in investors and creatives to know that there is a forum, there's a methodology, a mechanism through which they can enforce their intellectual property rights. So in this picture, the whole point here is that without intellectual property, we're all going to be living. That's the point. And there will be an industry to share everything from. So the big question is, it isn't whether we have intellectual property laws. We always have intellectual property laws. It is what we have done with it. The difference between the boring entertainment industry and the industry when it was stalled some years ago is what has happened and what we have done with intellectual property. Can you help me this? All right. Over the years, there has been continued work on creating awareness around intellectual property. And the results we're seeing today is a fallout, the benefit from all that work of creating awareness in intellectual property. Now, I will speak to the film industry particularly because that's one industry that it's easy to make the connection. In the film industry, we have got to a point where there is now a realization that IP contracts are an important element in film production, for example. As a lawyer, I was in this system talking to creatives, and they would say, oh, we do things, we just have some conversations, we have gentlemen agreement. And it was working for them, but I could never take them back. Because when investors really want to put money in an economy, they need to see structure. They need to know that certain rights have been clearly assigned. They cannot leave it to assumptions. And so when the numbers when I say numbers, in terms of the number of production that Nollywood was churning out, began to seem interesting, and you would expect that you have investors coming in. Investors did not find a basis to put their money because there was no structure. And so it became important for stakeholders in the film industry to revisit this issue issue around intellectual property rights, understanding how it needs to be harnessed, and IP contracts then became, it has now become a usual part of the production process, for example. Following that is also the realization that IP is indeed an asset. And it's not just about doing great, telling great stories. It's more about creating an IP asset that is viable, that can be transferred, that can be commercialized. I would say that today, the collateralization of IP has become a reality in the film industry. There are many agreements, many investment agreements that are based solely on the IP rights and the collateral. These are, all of this is coming out of an awareness of what IP is and how it will and it must be a part of the conversation in order to take the entertainment industry forward. And of course, IP enforcement. We're seeing that people are more aware of their rights, and so everyone is now more protective and looking out for, to ensure that their rights they're able to make commercial gain from their IP rights. What are the growth indicators? When we say that the entertainment industry is growing, the typical thing we think about is the numbers, and I will show you the numbers. But I'd like to look beyond the numbers to see what it means for an industry to actually grow. What are the things that are adding up to that number? It's not just the sale of films, for example. It is the fact that several things are happening behind the scene. So for example, there's more employment. The entertainment industry, as of 2021, there was a report that confirmed that over 300,000 people were engaged directly by the film industry in Nigeria, just the film industry, not talking music, not talking arts, not talking publishing. And that's an indication of growth, because that certainly wasn't the case many years ago. There's also a bigger ecosystem, and I did mention this before, that the entertainment industry now has more layers of service providers. Lawyers are now being invited to the table. Accountants are now being invited to have conversations. Even within the core creative space, if you go through the credit bills of a film made in 2023, you will find that there are so many contributors. In some cases, over 150 contributors. If you check the films of 10, 15 years ago, maybe it's just 7 names to be there. What does that mean? There are more people feeding from the entertainment business today than there has ever been. And it's all because IP is becoming more relevant and is being applied in a better way. Of course, the figures from cinemas, box office, is very telling. For the first time, we had a Nigerian film hit #1 billion last year. That is tremendous. And that's something we haven't seen before. Again, it comes back, it's a ripple effect of intellectual property handled right. Digital distribution has taken off. There's no going back on that, whether it's streaming video on demand or whether it's streaming music. Digital distribution creates access, and of course that also means that there's better accountability, because with digital distribution you can more easily determine who and where is listening to what, and that is another indication of growth. Of course, foreign and local investments have poured in a lot more. I need not say more about, I'm sure most of us here have Netflix, we have Amazon, we've had other players, Canal Plus was here, and beyond the big names you see, I can tell you there's a whole lot of investment activity happening within that space. And there's better structure. That's something I've already talked about. Now take a look at this chart. This summarizes the story. I don't need to say anything more. In 2014, the industry made $2.01 billion. Right? This statistics is from Statistica, which is a well-known public information source. And see where we are as of 2023. Does that show growth? What do you think accounted for that growth? Intellectual property and and awareness of intellectual property. And I think I will just end with this because my time is up. Intellectual property is worth more than we think. It's 10 times more than we think. And the question is, what are we doing with intellectual property? Thank you for your audience.
I think we can do better for that part. So for those just joining in, we welcome you once again for this event, and we'll be going on to question and comments. For me, while I was sitting down there, I really learned a lot from this Ngozi about the business side of intellectual property. So I'm sure that some of us here and even online would have questions, and we've had 3 speakers, back to back, talk to us about intellectual property and public domain. So I'm sure that there will be questions or comments, maybe things you would like to add to what they've already said. So please, if you have questions, you can just signify by raising your hand, or you want to make a comment, you want to add to things that Ms. Ngozi said, or Professor Ifeolu has said as well. Question? So we don't have questions, right? Or oh, okay. So there's a question for Mr. Ngozi.
Well, as we found to be quite engaging, there's a practical aspect of it. Yes, I'm curious. Suppose I have a phone, but I don't have a screen. What about image entertainment? I have a phone, but I don't have the romance and all these things. Now as a lawyer, I engage you. How do you quantify? How do I place value now? That's the money I'm bringing into the industry. How do I recoup my investment? As in my own protection beyond protection of the performance.
Thank you for that question. It's a practical question. As an investor, you're interested in investing in the film industry. How do you recoup your investments? That's the question that lawyers answer every day, because our role is to create the documents, the contractual arrangements that ensures that the money you're bringing in is first of all secure. If you think about film, for example, let me bring down some different statistics, facts. If you want to invest in film, you have determined that this is the film I want to invest in, and there are parameters for you to determine whether or not you think that's a good investment. So you're not just going to invest if you put yourself up to it. But if Kenya expert tells you, I have a project, if that secretary tells you, I have a project, because you have seen their track record, you have faith in what they are able to create. Because you don't think about creating things, it's not there until it's produced. And you're investing in what isn't, it's not like you're buying something that you can see, it's a projection, right? And so we come in as lawyers to help you create the contract that ensures, number one, that the film is produced, and there are layers of things that are put in to ensure that you're not, it's not just left to the producer to determine whether or not she will produce the film. Because you can give you the money to produce the film, and I do for my birthday, I do for something else. Or I can even start the film, and and somewhere along the line, the story is not good. Something can happen. And we find that many times the collateral for the investment is the film, it's the IP that doesn't exist. And so it's a transaction, a commercial intellectual property lawyer's role to step in and structure the arrangement in a way that the IP will be made, and if it's not made, there are buffers, there are fallout, there are buffers, I would say, to ensure that we are able to get some kind of comfort. Number two is to ensure that there is a clear understanding between you, the investor, and the production company on what you are getting out of it. Are you investing in equity, in which case you are saying whatever the film does, and if the film does well, I'll take a percentage, if it doesn't do well, I take the loss. Or are you making an advancement, are you making a loan, are you providing a credit as a loan, in which case the production company is bound to pay you your money when you are on the film. And this is a whole conversation, it's not something I can pack here, but I just want to assure you that there are solutions. And intellectual property lawyers that deal with entertainment type work, you will be able to help with that.
Thank you very much. I'm sure Shai will be able to answer your question, ma'am. So are there any more questions? There's question online. Oh, okay. Okay, so while we get the question online. Okay. Okay, so if you're online and you have a question, can you please unmute and speak? Thank you. Yeah, we can hear you. Good afternoon.
Yes, I already posted my comments. Hello, good afternoon. The chat.
Yeah, we can hear you. Good afternoon.
The chat box. Yes, I already posted my comments. My name is Michael Akon, the chat box. Don't just articulate it. My name is Marshall Akman, I'm a legal practitioner, also in copyright. I want to comment briefly on the presentation of Dr. Nubiki. I said it was quite a fantastic presentation, and especially I want to comment showing the different aspects of the public domain, which was copyright. Showing the barriers to copyright. I observed that the public domain cited copyright. With respect to performing public domain works of cited things like works of very works of famous artists. I noted she was popular the sound recordings. Interestingly, she was talking about the sound recordings. Interestingly, they are also on the line composition, performance recording, and they are also on the line. It appears that those musical compositions have difference, or it doesn't appear the right thing is that those musical compositions, those and the French compositions recorded to sound recording, it doesn't appear the right thing is that those musical compositions that were eventually duration of the sound recording is 70 years after. So as a duration of the it is very dicey that if after the one approaches of it is very dicey that if might run into problems the infringement of the underlying musical and recordings only rights might run or even the performance rights. So that's why I want to highlight the underlying sound recordings. It may not be safe to rely only the performance on. So that's why the term of protection of sound recordings, it may not be sound recording has a right on the musical composition protection of sound recording because the lyrics, the sound recording has a lyrics rights with the musical which addition and you show the lyrics, those are the comments, the lyrics Thank you. In which I consider mutual. So, those are the comments I need to make. Thank you.
Thank you very much, online audience. Thank you so much for that comment. So, you have a question, ma'am? Oh, okay.
Just a kind of answer to Ramadan's question. Actually, I mean, standing in the contract, the signing of the is not involved as having the analyst such intellectual work. Those who are really practitioners, who are screen analysts, who can analyze the data or the meaning of the legend very well, who are who are kind of educated in this aspect. Maybe in the aspect of in the aspect of understand that need to put the analytical creation analyzing to make sure that this particular play will attract the audience and get close, and the artists that are going to interpret all these plays, how good are they? Are they really, you could have a very bad play and you could have a very good interpreter who interprets the rules even more convincingly than the story itself. Now when you have a very good story, you understand what I'm saying. So you have to have professionals that you trust, that you already have the kind of whatever about. How can I say knowledge about the person of the professional only on legal reasons and legal basis you can get a body pass, or that you can show what you want to put into the legal and Thank you.
Thank you very much, Mark, for that. So we have another question for this university. What is the most severe possible punishment for copyright infringement?
There's a criminal act, right? That you can have criminal liability. On the civil side, number of things in our work that we do. There is no prescription as to what highest liability from the commercial context, criminal context, what law is prescribed. So, on the criminal side, however, there are also criminal liabilities subject to certain conditions. There's actually the potential to be. So that's the answer. The civil side, but the criminal side, you can actually go to convicted for because I hope that's answered.
Thank you very much. So please can we have the
But what the law says is that, for example, punishment for a crime is 5 years. That is the lower limit. That is the judge can decide to give 5 years, or depending on the circumstances of the case, the judge can decide to give as much as 10 years, 20 years. So that's what the law provides. So the law is not about the maximum, but it is the minimum. So wherever the law says, or they are going to enforcement of copyright, so the law will prescribe 5 years minimum. So you can go as much as 50 years, depending on the circumstances and the
Wow, please can we clap for her, please? Okay, so this will be the last question before we take on the next speaker and then go for our tea break. So this last question is also directed to you, Ma. How can we, as part of the creative sector, leverage out intellectual property to promote a more sustainable future? And what are some successful examples of this action? Okay. How can we, as part of the creative sector, leverage out intellectual property to promote a more sustainable future? And what are some successful examples of this action?
Okay, so the concept of a sustainable future is key to success. That doesn't, that is not success. It talks about progress that is not, that is sustained, right? And to do that, in the context of economic conversations, we're talking about building an industry with those that allows those coming behind to also take advantage and, leverage on the sources of others. For the entertainment industry, in fact, the creative industry as a whole, the journey has started is waking up to the attitude that intellectual property rights need to be considered as an important element in all the conversations within the industry. Now, IP rights have such a long, have such a long lifespan, and within that lifespan, and create structures to ensure that we can continue to leverage on intellectual property. When you listen to the public domain, and we're talking about public domain today, and I say that the whole essence of intellectual property is to enable access at the end of the day. So what IP does is to encourage creatives to contribute their creativity to bring it on board. So they don't exclude it for only a period, and it goes into the public domain. So at the end of the day, the public having access to that information is the better for it. And that's what becomes sustainable growth, because the next generation has a reservoir of publicly available information where they can pick up from and build the next layer of innovation. We will not make progress if we're all starting from scratch. So we all have to, we're all continually building on what others have done. In the creative space, you must think that you are building on what others have done. You also should be building on what others have leveraged on, because your IP rights will not be forever. I think about Intel, for example, the defense system. In fact, the law requires you to disclose your defense system so that someone else can practice it. But the law will give you 20 years, say nobody else is going to do it. But after 20 years, guess what? Everybody's rushing them to say, okay, how do you do it? And they see how you did it. They can do it. They can now build their own innovation on that. That's sustainability. I think that the way our technology has developed, the art has developed, when creativity moves on, that succession of ideas, the works of Shakespeare, for example, it is a public domain, made up as one public domain, but we still leverage on Shakespeare. Our children are still on Shakespearean literature. That is an example of sustainable IP rights in creative space. So that's something we can build on, whether we're doing music or whatever aspect of the creative space. We must be able to do it. Thank you.
Thank you very much, Mom. Dr. Ugui, please, if you can hear me, Mom, do you like to add anything to what Ms. Ogosi has just said? Oh, okay. We apologize for that. Moving on, we would like to call on one of our virtual speakers before we go for our tea break. Would like to call on Dr. Andrew Wallace. Dr. Andrew Wallace stands as an associate professor in law and tech. Our specialty includes arts and law, IP law, and internet law. As you can see, our bio is displayed on the screen already. So Dr. Andrew will be taking us on the topic harnessing the potential of cultural heritage in the digital age for achieving the SDGs. So, Dr. Andre, if you can hear me, please kindly take on now.
Ghost and God wants that.
Alright, we'll work on that for this moment.
Which is giving a little bit of feedback. So, sorry, should I go ahead and share my screen? I'm sorry, the audio is not coming through very clearly. So, sorry, should I go ahead and share my screen? I'm sorry, the audio is not coming through very clearly. I'm so sorry. Okay, I'm going to share my screen. I think there's an issue with the microphone, but I'll just go ahead, and if there's any issues, maybe it would be best to mention it in the chat. So let me just, so sorry. Okay, I'm going to share my screen. I think there's an issue with the microphone, but I'll just go ahead, and if there's any issues, maybe it would be best to mention it in the chat. So let me just go ahead and do this. And oh, I'm so sorry, one sec. Stop sharing this again. And could you see my screen share? Oh, I'm so sorry, one sec. Stop sharing this again. Could you see my screen share?
No, we can't.
Did that work, or?
No, we still can't see your screen.
You can't see your screen. You cannot see it. Okay, let me try this. I think there's an issue with PowerPoint, so that work, or I'm gonna present from, we can't see your PDF, so this will not see it in the better route. Let me try it. Here we go. How's that? There's an issue with PowerPoint, so instead, I'm going to present from, so we're going to talk a little bit about harnessing the potential of advantage in the digital age for achieving the SDGs. There's been such presentations of our digital age that was really amazing to really visit and talk about. So really excited disconnected. It's going to definitely talk about this in more detail. It's going to manage a survey of what institutions do when they digitize their collections in the name of openness, right? And so according to our survey, we have several rated institutions that have acknowledged our survey. Principles of independent and then specific assets. And so that also we have over 70 institutions under open licenses that allow for commercial recording stuff and notifications. So it's, it's important that there's at least 1% of institutions globally that are actually published in recording in progress in an open way, which means this is it's an exception rather than one rule, because most institutions are actually publishing in collections. The reason that in an open way, which means that this is, it's the exception rather than a rule, and most institutions are claiming copyright in digital collections. The reason it has to be important to talk about is that it really deflates the creativity and cost of the public domain and the opportunity for quality creators. So just to kind of give you a bit of an example, so on the left we have a two-dimensional photograph, right? It took a viewpoint film during digitization of the prison work for a lot of the modern museums, of course, because I made creative
Bluetooth mode. Connected. Disconnected. Connected.
Expensive technologies to create, but because it is a copy, it's a digital surrogate, it's a faithful reproduction of a work that's not protected by any rights, that 3D model doesn't get recopied. And so the museums acknowledge this by publishing it as extract and CC 0. And it's important to think about because when we see people claiming rights and digitizations, it has an impact. And I wanted to show you the actual mapping of that impact. So according to our data from the Open Green Survey, this is where the institutions are that are digitizing collections and publishing them open access. So it's really important about this is these are all countries with histories of imperialism and colonization, wealth extraction, and all sorts of dynamics that then feed into what intellectual property, digital engagement, and things around them. But it also, relates to the languages in which the metadata and other sorts of information are that are attached to the images that are published openly and inform a lot of the data sets in which new technologies are being trained. So there's a lot of inequities built into the system to begin with. So now I just want to move on to where the SDGs can kind of come in and complement this. And I think it's really important to start with good health and well-being, because we know there are many studies about the role that cultural heritage can play in promoting mental health and well-being, and that being essential to sustainable development, and how cultural heritage and engagement with cultural heritage and autonomy and agency, particularly for marginalized groups, is really, really important, right? So we're thinking about personal context and cultural backgrounds, and different forms of heritage, and all of this being inextricably linked to mental health and well-being. And so to take us into this directly, throughout the state report on this topic, but it's really important to think about that, especially in terms of intellectual property and how we create intellectual property that can respond to these things. So the example that I want to highlight is actually by a group. There's a project on London, in collaboration with Ibn Hussein and Muslim, where they set up a workshop to engage small communities in the UK with the creative use of immersive reality and web technologies to conceptualize what is the object or need to be used functions to which they belong. So we brought together oral histories and different forms of archives and knowledge held, physically held, and also intellectually held by the people and to whom these objects relate, by creating these alternative reality spaces supporting national heritage. Acknowledgement that can complement the lack of information and the lack of knowledge that's out there about some of the things that need to be corrected. So while we do have, of course, different educational resources and all kinds of really, which are for the purpose of creating new knowledge and correcting it, the student record is also essential to quality education. And so the project I want to highlight here is on the African Digital Heritage in Cheltenham, the Museum of British Colonialism. So Chow worked on studying the oral histories, site visits, and local archives, the histories of the Myanmar Detention Center and concentration camp, which is now high school. And so she reconstructed virtually confined themselves to torture rooms and the officer figures of torture purpose into spirit rooms. And this is the beginning of Chow's trying to really use technology to find out the suppressed histories and its injustices while making it available to a wide audience. But it really also highlights the tensions of gaining access to the extensive archives that are held in the UK, both physically and digitally. As well as the fact that that knowledge is out there. It may not be written down, or it may not be recorded in ways, right, that some of the archives in the UK would have done, but in fact it also not just supports the record, but also complements it. And so these are also, of course, important contributions and protected by intellectual property that create more quality education that is made available also through digital access. So you can see these models and videos of them. And Chow's been working in collaboration with volunteers and colleagues to really document and digitally implement these sites. So another example, which is really important to highlight, is a project called Personal Knowledge. And so the issue that knowledge is trying to highlight is that knowledge infrastructures themselves are already biased against marginalized communities, in the fact that they're expected to be written, and most of the knowledge in the world is not recorded or documented. Especially when we think about, populations where people are living in diaspora, where people are trying to participate in online spaces, and those spaces more effectively and equitably like Wikipedia and the ways that volunteer editing creates inequities. While in Wikipedia will be a really important resource, it's not largely supported by a certain demographic of people who have time and ability to edit. So this launch is really trying to kind of think about what a radical reimagine of the internet looks like, so that instead of building dependent on people. And some of the work that they're doing is also to critically examine the public domain and how to make the information online more inclusive. I'm sorry, there's I think someone's they have a really wonderful guide on how to edit Wikipedias and institutions. Sorry, thank you. They have all kinds of documents and resources about what to use in the collections for in order to correct some of the ways that the SDGs are also responding to. My slides weren't advancing, I'm so sorry. I'll just quickly show you. This is the Chalice Project, Academic Heritage, Museum of British Colonialism. This is the knowledge website, and also different resources that they've been working on in our gender equality. So something that is also really important to consider when we think about open access is the types of collections that we see as being representative, right, universal and common cultural heritage. So the information that's going to be maintained around them is obviously going to be a lot more detailed than people have felt. Certain things are more important to study than others. The collections themselves also carry a lot of biases and canons that create inequitable outcomes for different genders. And so this is where it's really important to start thinking about inequalities and equity instead of just equality. Because a lot of, I'm so sorry, it's going to get loud when it's right under the space. A lot of the collections that are out there are quite ordering the empirical evidence of absence, right? They're data, but they're not context. And it's that context that becomes really important for people to contribute to collections to correct record when you're doing so creating as a property truly is valuable for bringing forward the stories that we told, which all contributes to reduced inequalities. So to kind of begin, it's really important again to go back to this now and think about what we countries with histories of colonization and imperialism need to be differently about the ways that IP can be transferred and restored with the actual communities and owners of that knowledge, property and cultural heritage. Because otherwise you're going to continue to have the global minority only producing knowledge for a global majority, learned to written in English, and all of the data structures and issues that I talked about earlier. And so this is how cultural heritage and IP really starts to really all of us. And it's important to think about it as the context of TRIPS and other international agreements have also contributed to wealth and knowledge extraction from developing countries to countries with developed markets and the ability to then insert IP into markets that they share more efficiently. Which so sorry, the audio isn't working. So I think someone tried to say something, but it's not clear. So, okay, I just might quickly wrap up because I'm about to conclude. This is what becomes really important when we're thinking about innovation and who's being compensated for a lot of the work that's being done and whose labor is deemed to be important, right? When we then move into artificial intelligence and IP and innovation, which brings us to thinking about sustainable cities and communities and using IP intentionally to create the sustainable communities that we want. I'm seeing a couple examples here of how we can use digitization and disruption to create different sustainable communities and digital spaces. And so I'm just going to go through quickly and suggest that we look further into it. This is why I address the SDG 8 last. Because what all of this is kind of telling us is that we really need to start thinking about better data and intentional growth and connected growth, where there's over-representation and there's a lot of exploitation of brain, especially through new forms of technology like intellectual property. So with that, I might highlight and share some images paper and also Keynote, which is available online. And then thank you very much. I'm sorry that in this space that's challenging. I was probably because it was about 30 minutes ago, so I didn't for this. That boring maintenance.
Thank you so much, Mr. Andre. Can you hear me? Dr. Andre, can you please hear me? Oh, okay. So we have a question for you. Can you please tell us what are some gray areas in joint authorship? Oh, yeah, so I said that what are some gray areas in joint authorship?
So, that's a jurisdictional question that I don't think is necessarily prohibitive, if that's kind of where this is coming from, because all, in these days, trade gets managed by contract. And so gray areas themselves will definitely arise, but I think it usually comes down to really trying to think differently about the way that we construct contracts, because especially as lawyers, we try to accommodate risk and future uses and thinking about who should have ownership. And really, if we do that within the IP framework, it produces results where there's one person kind of controlling things where permissions are required. And so I think that there's a lot of interesting pathways forward to think about contractual provisions differently that share the rights, or even grant people the ability to use things without permission of the other authors. So really it's just kind of thinking about a little bit more creative around the confines of joint authorship, while also recognizing that there should be more authors and more people credited in a lot of these projects that aren't being given the credit that they deserve because of authorship confines of intellectual property. So I'm not, hopefully that kind of speaks to the underlying kind of should be grasped.
Okay, thank you very much, Dr. Hanji, for answering the question. So right now we'll be going for a tea break before we move on to other sessions for today. So we'll be taking this exit to Augustine, to the room beside Augustine Hamadi's hall. So we'll have to go row by row, please, so that outside does not get crowded. So please, we'd like the first 2 rows, so please use this exit to go out for their tea break. The tea break is going to be for 15 minutes, and then like that, so that outside doesn't get crowded. And for our online audience, we'll be going on a tea break, and in the next 15 minutes, we'll be coming back to take on the next session of speakers. Thank you very much.
And we have this popular song called Game Changer. I want us to kind of understand what we're here to do and understand the direction of every corner, as simple as it can be. That's what I'm going to do. So I just look for a few of you most of things, where we're sharing. This is the process that we get to everybody. Try to cover is over the body. But behind is the drums, we see African attires, we see textiles. If you watch the video, you will know this is Nigeria. You will know it's about Nigeria. You will know it's about our traditions, our customs, and the way we are. You not like tell me the leather company did not start in Africa. It began there. We had our systems of productions. What are we going to do? Are we supposed to fit into the system? Or should the system fit into us? Because we, as a being, and I was also the shapes, we need to be like so clearly, you have two parties in the game, and you have the indigenous communities. Now, let me give you an idea of indigenous communities. Okay, let me give you an idea of indigenous communities. Many of you know Eleguiomos. Have you seen them before? herbs for children. They're in the market, they're everywhere. They're everywhere, don't you know? That's intellectual property. That's traditional medicine. Kids have rashes all over their body. Kids have some form of ailment. That's IP. That's them thinking. And these statues didn't started a long time ago. A long time ago we could heal ourselves, couldn't we? A long time ago we were hardly sick, were we? Because even our food then, they were medicine. That means you don't know. It's vegetable, but it's medicine. I was telling somebody, I said I'm going to cook. I have to. I've done it once. I think I'm going to do it again. You know when you blend ugu and scent leaf with bitter leaf, and then you make serious delicacy. But it's medicine. You know that. Did anybody teach us to do that? Do you know aspirin was first discovered based on herbs? It wasn't from anywhere. From here. So let's start from the bottom. Let's start from. Do you see women who farm? They farm down the farmlands, isn't it? Agricultural products. That's still part of intellectual property. How many of you have noticed that clay pots are now in vogue? I want to buy clay pots, but I'm not going to buy that expensive one. I saw one. I should sit down to mold it. That's intellectual property. Pottery. That's intellectual property. Sculpting. That's intellectual property. Carving. That's intellectual property. Some of you here, or all of us here, have intellectual property in our head. We have some form of intellectual property. But because we don't even know it's intellectual, what is intellectual property? Creations of the mind. Anyone based on the ground that is not real. And it's nice now that we're all doing it. Afrobeats has gone everywhere. What do you think is independent? African music. The inspiration is from here. Who knows the real language for us? And the Albert Okunde. I'm sorry I talk much from the south, but I'm going to do this. I have to start digging into other arts and other indigenous communities across Africa, because I can now make better examples of those who in the past dealt with either plays. We are very good at storytelling, whether from the south, from the east, from the west, from the north. What is Nollywood based on? Storytelling. Storytelling. Where did they say before? Under the candlelight. I don't have no candle. Under the moon. And yes, Yoruba stories. We are very good with stories. So our survival mechanism is what? Intellectual property. You didn't just do it for fun. We did it to exist. And yes, we did it for entertainment as well. We even did it for worship. We're still doing it. Have you noticed custom is resilient? No matter how much our children speak English, that custom just does not want to disappear. And it wouldn't disappear. Even if they speak English till tomorrow, they still want to wear their attire, their badges. So you have different areas of intellectual property. You have the copyright, and I've told about copyright. Music, dance, performances. You have patents. I've told you about medicine just now. You have geographical indications. Jebugai, Jebu, of other rice. You have what other area? Trademarks, symbols. Have you noticed that some of these Nigerian designs, they are traditional symbols that you have on them? Unless you want something else. Who taught us how to do that? Our forefathers or ourselves. Sometimes you teach yourself how to do something, but you don't even know it's intellectual property. So I'm giving you examples, even though I've talked about that. Then we also have our cultural heritage. So a lot of you must have heard of the Benin bronzes. You've all heard of it. Who has watched the movie as well, the Benin invasion? And I watched the documentary, and you had some professors from the UK saying they could not believe that Africans made those things. How? How would we make such beautiful things? The bronze and other types of metals. Have you seen some carvers carved from Nigeria? The carver is unbelievable. How could they use wood to create such things? We didn't just start now. We started even before the era of rock culture. It's always been a part of us and it continues to be a part of us. But we need to go, not just there at the national level, we need to now start going into the interiors to educate us in different languages. I think cannot continue to be in English language. And we expect that cover in the village that does not know English. Yes, I just forgot that name now. She disagree with me in the village to understand that this thing I do, if I make lots of it, it will earn me an income. It is mine. I am known for it. I can put a symbol on it. I can carve a symbol on it, and I make money. It will definitely reduce poverty, isn't it? And then we go home and we can let people do what they want to do. It's not the time of you must be a lawyer anymore. I'm a lawyer, but it's not at that time or doctor or anything. You want to sing, you want to play, you want to carve, you want to pay. All these things generate an income. Okay, use this card. Might be the rest is yes, sir. Might be it's gone. Let's take this.
It was frozen.
Okay, it's supposed to be immediately. So you see, can you compare tradition to technology? Even though we need technology. Don't get me wrong. Please don't get me wrong. Technology has its role. Tradition will continue to have its role. You understand? They both have their roles. And I've even said some things. So I said, for us, intellectual property, they are survival tools.
All those people are not.
So I gave some examples. I think the first one was it shelter? You have, who's seen some architectural designs from the north, their houses, even from down here. You look at the Oba's Palace in Ile-Ife, Oba's Palace in Benin, Oba's Palace in some other parts of Yoruba land, the east, the north. It's beautiful, isn't it? So the architecture is in our own way, showing our own traditions and stuff like that. Then we have that shelter. Then you have clothing, Nigeria, shoki, different things, cheap materials, the northern indigo dyeing materials and stuff like that. Then you have food. You know, we have different types of food from different types of places. I should have put more, but when I was like, let me just look at those two. There's nobody in this room that does not know Ghana. So let's do that guy and some other things. All these things I'm talking about, sincerely, they're intellectual property. They are as simple as that for you to understand. So you need to celebrate that boy, 16, 12, 13, 14, who is thinking of something very creative because of his environment, or some form of recipe, or something based on where the child is from. Encourage, but make sure the pass my age, but encourage them to do those things. So tell me, what is more sustainable? Clay pots than tower? Which one? Clay pots or tower pots?
Okay.
So when they say sustainable, that's what our tradition does. What's better? Banana leaves or lime? Yes, didn't I saw a program where the Chinese people were using banana leaves as plates? Turned it to plates. We have it so much and all around us. We need to understand it. And we need to create mediums for us to understand it better. But we need to start going back into the interiors. Back. They're surviving. And they're surviving. It is not just us all the time at the national level. We need to go down to the communal level. And we need to be able to see it and perceive it and smell it and hear it. But they wouldn't know unless we explain to them in the manner in which they will understand that you can't keep doing this without making anything out of it. And some people will come in and take it and it's theirs. There was a long time ago I went to Tejushu and they said there's this woman in Tejushu market that she gives you this cream for your hair. Now all these you know that 50 and above, you're having patches in front of her hair and so on, that she'll mix it together for you and you know it'll be good for your hair. So I said, Mama, Mama, what do you put inside this thing? Say, you think I'm a fool? So they've done it for years. They will use style to ask you, then you see it in the bottle. Why are we not educating them or supporting them or creating funds for them to put it in what? Bottles.
No, wait.
That's how we elevate our indigenous communities. We need to. Otherwise, we can't just do this at the top level. And definitely, how many of 200 plus million people are educated like us, or educated? Many more are in the interiors. What are we doing about the interiors? Why? The intellectual property can be the game changer. Can we go to the next slide? Oh, let me, is it what? It's not with this.
Everybody.
Oh, okay, thank you. I'm like, the one before this, okay. The one, I think there's another one before this one. So how does the game changer? Now the game are indigenous community. The game, indigenous communities. The game, indigenous intellectual properties. Yes, there is indigenous intellectual properties because that is how they want us to perceive it. So we claim it. It is peculiar to us. It is known to us, and we can enrich ourselves from it because why? We have been blessed with so much biological resources, so much creativity, so much skills in different things. So how? So at this point, we say how? Perceive intellectual property as a tool for sustainable development, which it is when it comes to indigenous communities. I'm just giving an example of the clay pot. I'm still looking for that clay pot. If you know somebody, hook me up. I don't want those ones to discover again. I want the ones that I know who made it. The next one is perceive intellectual property as more than a tool to prevent unauthorized use. That's how it started. These issues about indigenous knowledge and all that. People were taking it. People were taking ideas of herbs to cure different ailments away from us. People were taking ideas regarding creativity away from us. So that's how we started. Initially, all this was regarded as being in the public domain to take as you want. They forget that they don't understand us. While the West is pro-individualism, we are pro-individualism in communalism. We do for others to enjoy. Not to steal, but to enjoy. So all this, the way we perceive IP has to change for these communities, not for them to fit into the system, but for the system to what? Fit into them. By recognizing their languages, their peculiarities, and the things they need, and the understanding they need to develop themselves as entrepreneurs and small-scale businesses. So it's not just about preventing stealing anymore. It's about us making money. It's about earning an income. It's about development. It's about growth. I'm so sorry, it's sad. Sometimes when you go to some of these communities or some of these villages, young people don't know what to do with themselves. So they still, they get pregnant. Whereas if they had somebody to educate them, look at what Tuji Onokoya is doing with chess. Amazing, isn't it? Where did he go? Into the interior. So we need to do these things for us and our people. Perceive intellectual property as a tool to monetize creativity. They need to understand that what they are doing is not just to make current profit. So next time, this clay pot woman, after I bought my own, maybe she's selling for 2,000, she will elevate it to maybe average of what you see online, 25,000. She needs to understand that what she's doing is significant and can enrich her. It's very important. Perceive indigenous intellectual property as safe as modern. Yes, we have customs. For instance, I don't know if you share this idea with me. About Benin again. I love the whole Benin because when it comes out, when there's a ceremony, you see those beads. You see his attire. Unbelievable. Can a common man share the same attire with the other Benin? Is that not monopoly? And they say we don't know monopoly. We don't know individualism. We do know these things. So it's not strange for them to accept intellectual property. They just need to understand how to use it in their favor and for their benefits. So, decolonize intellectual property. One of the means of decolonization of intellectual property is the language thing. How can Nigeria not have languages in different laws in different languages? Why? Awareness programs in different languages. I don't speak Igbo, so let me choose the Yoruba that I know. And they hear on the radio, you understand? You understand? And then they have that telling you about this amazing thing which is called intellectual property. So they say, So me making maths is a big deal. Me weaving this is a big deal. Me making Nigeria, it's a big deal, especially those original, organic ones, not China Nigeria. Okay. It's a big deal. But why? We're letting it erode. We don't understand the fact that it's a big deal. We need to understand that it's is a big deal. Communal understanding of monopoly and individualism is not us to understand. We understand it, but we need other people from other jurisdictions telling us this thing is a good thing, to understand it and work with that. I'm not always for a sui generis system when there's a system on ground that needs to take into consideration other communities or jurisdictions that also are creative. Another issue that they used to have with indigenous knowledge systems is the fact that they say we're basically oral. Who has heard of rock art? We have written forms, we have oral. But what is the big deal in saying oral indigenous intellectual properties be protected by copyright? Is it a big deal? No, it's not a big deal. That is how we are, what we are. It is original, isn't it? So that other people don't take it. Fifth, I've said that, I've talked the last slide. I've talked about that. Last slide. Conclusion. So the conclusion, you see, 21 minutes out of my head. I should take it 2 minutes now. Like I remember, conclusion. When the game changes, it's about the game changer. When the game changes, there should be reliable flow of income for these communities and even for us. There should be poverty reduction, documentation of indigenous intellectual properties, development of indigenous intellectual properties and communities. And you saw the rest. Thank you so much. I'm so grateful.
That was a wonderful presentation. Sorry. Okay.
I wanted to know.
Okay, on to the next presentation, we have Dr. Kunle Ola. He is an associate professor and deputy head of school at the Thomas More Law School, Australian Catholic University. He researches in the area of IP, company and migration law. With a round of applause, let's welcome him virtually for his presentation. The topic is the role of IP in enabling access to and demonstration of education. Can we have you, sir? We need to take the next presentation by Professor Ibrahim Kayode Adams. Can we have the bio for Professor Ibrahim Kayode Adams? He is the former Dean of Faculty of Law, University of Ilorin. He has engaged in the teaching and supervision of labor law, industrial and property law, and revenue law at both undergraduate and postgraduate levels. So if you can hear me, Professor Ibrahim Kayode Adam, if you can hear me, can you proceed to your presentation? Sir, Professor Ibrahim Kayode Adam, can we have you, sir? mute so that we can hear you. Kindly unmute so that we can hear you. So kindly speak louder so that we can hear you. We can't hear you, sir. Okay, yes, sir, we can. We can.
All right. Here is Professor Ibrahim. Why I did not respond immediately because I thought we were inviting Dr. Fuyola to take the case. Now, I want to begin by I would like to share my
Yes, we are continue, sir.
Okay, thank you. All right. First is, what is trademark? What is the nature of trademark? Trademark means the mark that is used or applied or affixed to any goods or services for the purpose of indicating a connection between the goods and a person who has the right, either as proprietor or as the registered user of the mark, in the course of trade or in the course of services. That is what trademark means, according to the Trademark Act, 1967. Now, this definition of this nature of trademark excludes certification trademark, because certification trademark has its own unique character, in the sense that it is a mark that is registered or deemed to have been registered for the purpose of certifying the standards of certain goods. So, and next is, when we say mark, what is it that we mean by mark? There are basically two types of marks. You have the traditional marks and you have the new marks. The traditional marks are those that include devices, brand, heading, label, ticket name, signature, word, letter, or numeral, or any combination of all of those. So if you have words, you have letters, you have numerals, you have pictures, all of those will represent the traditional type of mark. But then you also have the non-traditional type of marks. The non-traditional type of marks are such images that will probably show the color or the three-dimensional signs of a product. That's the shape of the product, the packaging, or the sounds or smells. So these are also form of marks that can be used in association with certain goods in order to advertise or to promote such goods. Generally, you can also classify trademarks into trademarks, into service marks, into collective marks, into certification marks, and also into well-known marks. So all of these are a kind of marks. Trademarks is the one that is used with trade. Service marks is the one that is used in connection with service rendered. Collective marks is the one that is used to distinguish goods or services rendered by members of an association. Whereas certification marks, as I said earlier on, refers to marks that is used to certify that certain goods live up to standard or meet certain expectation. Well-known marks also a form of marks have become famous in the market. They become uniquely known, famous in the market for reason of their usage in the market. So now, generally, by its nature, trademark is a form of protection. It's a form of protection given by law. And this protection comes with some rights. The right is known as exclusive right. So in the sense that to the extent that trademarks protect rights of individuals, so in that sense, it secures investments of the person, that is the owner of the trademark, with regards to his marketing efforts. It also promotes loyalty, reputation, and the image of the company. It provides coverage in relevant markets where it operates. And so it is also possible to license such rights and in fact can be assigned completely. So now that is trademark. What about brands or branding? Branding on the other hand is the image or the perceived image of a product. Is the perceived image of a product. It can also be evidenced or demonstrated. That is the perceived image. Can also be evidenced or demonstrated by name, time, term, sign, symbols, designs, all of our combination of all of this. These are the things that I think identify the brand with the maker. So that it is used to create image for a product. So the thing that is done to get a successful branding is that the owner or the proprietor of a good would have to ensure that it are the values and qualities that are relevant to its target market. So it will now emphasize on the feature of its goods that addresses or that meets the expectation and values of the market of consumers. So that is generally what the proprietor of a branded product would normally do to ensure that his product is able to make it and is able to succeed. And like I said, it is the kind of branding is very flexible. It's very flexible in the sense that it can be the totality of the product in terms of the entire packaging of the product. It can be in terms of the taste of the product. It can be in terms of the smell of the product, whatever. So this is also very flexible. And so in that way, you see that it is close or similar to what we discussed on that trademark. Now, therefore, it is necessary to now look at this connection between trademark and brands or branding. What is the connection between the two of them? Now, generally, one can say that while branding is the term that is used to describe the process of promoting goods, products, and services in the business sector, is the term that is used while in the business circle, they'll be talking about branding. In the legal circle, we're talking about trademark. And as part of their relationship, you now see that trademark plays a role with regards to branding. The role it plays is that any brand owner who makes use of trademark will get protection for his brand. And so, like we said, the mark that is used under trademark in association or applied to goods and services are the same marks that are used for branding. So, meaning that what the law requires for branding to become protected is the same as what is stated under the Trademark Act, and that is precisely what branding is all about. So, to that extent, the role of trademark is that it protects brands and branding and gives it a higher status. Because ordinary branding does not have what is required to be protected or to enforce the rights of the owner. But if it becomes a trademark, then it will be protected by law. And all the rights, exclusive rights, that will be given to the owner of trademarks will now be a guarantee to the owner of the brand to be able to exclusively exploit his brands without fear of infringement or unhealthy rivalry, let me not say competition. So here we have shown the benefits that trademark confers. We said it confers exclusive right or the use of the mark. The proprietor of trademark is able to recover monetary damages from any third party infringer of the trademark. The trademark will serve as an indicator of origin. It will distinguish the goods from other goods. The same that is intended for branding. And so it also serves as a symbol of quality. And it is an embodiment of goodwill and reputation of the proprietor of the goods and services. And so to that extent, it gives legal coverage to branding. So that's one of the general and major role of trademarks in relation to branding. And you know, as it is said, actually branding requires intensive capital sometimes to create. Also, it is a that a brand has acquired is a product of long years labor, long period of labor. You know, so for that, whatever has been invested in terms of money, in terms of labor, in terms of time, all of this can actually be secured, by trademark. And you also know that the kind of right conferred by trademark is such that it can be converted into economic gains, can be converted into real economic gains through licensing and through assignments. So now, having said this, we want to look at what role will this now play, will trademark now play with regards to the SDG goals. Now, the SDG goals, like we said, the Sustainable Development Goals is more like a call into action by all countries in the developed and developing world. Now, the main goal of the SDG that is relevant to this discussion on trademark is goal number 12. And goal number 12 concerns the need to ensure sustainable consumption and production patterns. The need to ensure sustainable consumption and production patterns. Now, authorities of countries that have subscribed to these goals have the obligation and responsibility to ensure that consumption pattern is ethical. Consumption pattern is sensitive to sustainable development. The same way as production pattern is sensitive to sustainable development. Now, this does mean that products that will be promoted and sold to the public are expected to be products that are ethical, products that respect the environment, products that have that nurture sensitivity towards the environment. These are the products that will be compatible with the SDGs, especially SDG number 12. Now, because the SDG is addressed to the whole world, countries, governments, organizations, business sector, non-state actors, individuals, it is addressed to all of these stakeholders to change their consumption and their production patterns that are unsustainable. And so because of this, gradually, the consuming public is already gaining increasing awareness about the need to respect and implement this sustainable development goal on the need for sustainable consumption and production pattern. And that therefore, this awareness has led to what is known as eco-conscious consumers. Eco-conscious consumers. Consumers who are interested in consuming goods that are friendly to the environment. Goods that will promote their health without compromising the future generation. Goods that will make less use and impose less cost on the environment. And we nevertheless meet the needs of the consumers today. So these are the kind of consciousness that has grown in consumers. So with this kind of consciousness that has grown in consumers, businesses too have recognized it and have started to rebrand. They have been rebranding. So what they have, in the name of rebranding now, they have gone green. So you have green branding, you have eco marks. The green branding and eco marks have now also surged up the market value of eco brands and green brands and eco marks have surged up to very high level, to the extent that the number, the report by EU in 2023 has shown that of the filings that have been made in respect of green trademarks, energy production, pollution control and transportation, all of these have surged up. The trademark filings on them have surged up. So that's to show that businesses are also aware of the sensitivity of consumers, and they are also now responding to it. So, like we said, that trademark is the one that businesses have to use to protect their brands. So, in this same situation, the branding, the green branding, has also been buying eco trademarks to protect their brands. So now there is a surge in this eco brand, green brand and eco marks, such that you now have labels on products showing either green leaves or green, the word green, or the word eco, or the word sustain, or the word the term zero impact. So all of this you will see, or you will see clear water in the labels. All of these are part of the things that are used as brands and are being used also as marks in order to protect. So they are, in some way, they are also a form of, they are trademarks that are used to protect the brands. Now, but this is not without its challenge, and that is precisely where trademark will further assist the SDG in realizing its goals, because it has been shown from reports, research has shown that most of the eco branding or eco mark, green branding that has sprung up across the globe, most of them are only making false claims. The claims are not in all cases correct. And so one of the ways by which we can, as the TM, the trademark, can assist in the realization of the sustainable consumption and production pattern is by refusing applications that are deceptive, application for trademarks that are deceptive. You know, that is part of the trademark provisions. So trademarks that are not that are deceptive will not be allowed to be filed. It will be refused. So that's one of the trademark can assist. Other way is that when trademark is creating confusion. So all of our words have been shown under the green branding and eco-TM to be happening. So that's why they say that most fashion, in the sense that it's just a whitewash, it's a greenwash of the products. The products will not meet the claims that have been made on the brands or on the labels. In order for a trademark to now assist in this regard, certain provisions of the trademark law we may have to be engaged. But that is not to say that just trademark alone will be used to do it.
I don't know
But
if we can.
it will be sorry.
The time is so sorry.
Yes, I will round up now. So, so trademark can be used in conjunction with other options. In conjunction with other options. Such other options like using the Federal Competition Commission, Federal Competition Commission. They can use also the Standard Organization of Nigeria also to assist, because they can be certifying. You know, the certification marks is issued to certify the standards of many products in Nigeria. So any product, like in other parts of the world, any product that makes a claim that it is environmental friendly, or it is green, or it is eco-friendly, or there are energy, low energy consuming, all of them will have to take certification mark in order to be able to. So all of this can be combined. And there is also need for NGOs, non-governmental organizations, class actions, and all of those can be combined to assist in ensuring that SDG Goal 12 is realized. So in conclusion, the discussion has been able to show that there is a relationship between branding and trademark. The relationship is such that the two of them, branding and trademark, can be used interchangeably. But the truth of the matter is that one is for business circle, the other is for legal circle. And the fact that trademark also assists in protecting brands. And ultimately, this role of trademark in protecting brand will assist in the realization of SDG goals by ensuring that the emerging green branding and eco mark does not end up misleading and deceiving the public. Thank you very much for the opportunity to discuss this topic. Thank you.
Thank you, Prof.
Thank you.
Questions after presentation. Prof, please kindly stand by. Thank you. Our next presentation will be taken by Dr. Kunle Ola. Can you please project his bio? I think I've read it. So he's an associate prof and deputy head of school at Come of more law school, Australian Catholic University. Can we hear you, sir, so that we can take your presentation?
All right, thank you very much. Are you granting me access to be able to share my slide, or are you going to do it on my behalf? Hello, can you hear me? Yeah, can you hear me?
Yes.
Okay,
We
thanks.
can.
Yeah, all right. I now have access. Can you see my slides?
Yes, we can.
All right, thank you very much. Good afternoon, everyone. My name is Kunle Ola. I'm currently the interim dean at the Thomas More Law School at the Australian Catholic University. I've been asked today to speak on the role of intellectual property in enabling access to and the democratization of education. And my presentation is going to focus on the role of IP in the attainment of SDG 4, which basically looks at education for all. So in framing my presentation today, I'm going to explore the role of IP in enabling access to education on one part, and the role of IP in democratization of education. But before I do this, I'd just like to use this opportunity to thank Niles, the Nigerian Copyright Commission, and Free Knowledge Africa for organizing this program and also for commemorating the World Intellectual Property Day. I mean, the fact that we can celebrate this day is a reminder of the fact that IP is making not just any small impact, but making global impact on nations, on lives, on institutions, and across the field, from health to agriculture to tech, and in education, the area that I'm going to focus on today. And I start by just thinking of the thoughts of Mandela, who mentioned that education is the most powerful tool to change the world. And if education is going to change the world, you ask yourself, so how do we get education? What does education entail? This entails knowledge. This entails information. And I mean, what role does IP have to play in this? IP has that legal framework that regulates the sphere in which education operates. It has that sphere, because it controls and regulates content, and it has the ability of ensuring that there are access gates and there are restrictions in that space, but not just for restriction purposes, but for the purpose of ensuring that those who create this content have a means, to be able to recoup their investment. But there are two sides to this coin, because whilst one is trying to recoup investment, there is another side to this same balance where you want access. So it's that interplay that we look at when we are thinking of IP. And we know that IP plays a central role because it's not just a catalyst in terms of creativity and innovation, but it's also an enabler in terms of granting access. So these are some of the things we're going to explore as we look through the role of IP in the attainment of education for all. But before I really delve into some of these thoughts, I just want to try to give us a few data, and I'm doing this because we're looking at IP from the perspective of an enabler in the terms of education. And we know that IP is what regulates this space. And in the space of education, one of the things we need to think about is how do we deal with knowledge? How do we deal with information? What is it that actually regulates this space? We know that intellectual property gives the author certain rights. So for instance, the right of reproduction, the right of translation, the right to communicate to the public, and as a result of this, authors are able to control to a large extent how people access their content. And there are industries that play within this space. And one of it, as it relates to education, is the publishing industry. Now, in 2023, we're told that there was about 91.39 billion made within this industry space. And there is a projection that, within the next, 4 or 5 years, it's almost going to hit about 100 billion. Now, those who play within this space, they're quite a number, and Africa also has its role in this space. But there are the big fives who really play within this space, and they basically control this industry. Now, when I say they control, when you look at their total earnings, it's about 12 billion. So we're talking about over 10% of the whole earning globally. And then we ask ourselves the question, where is Africa in this game? Where is Africa in this circle? Now, a 2019 publication made it clear that in Africa's terrain, with over 1 billion people, we generated about 1 billion in terms of a total revenue in this space. And if we are going to work towards attainment of SDG 4, and that's education for all, we can simply put out ourselves saying, yes, we want to be able to have access to information, but a deeper question is, how are we contributing to the knowledge for which access needs to be required? Because he who plays the piper is going to dictate the tune. Now, the publishing industry are actually not the content creators. They are like the access gate. So you and I, who are authors, we create this content. And once the content is created, we pass it out to these authors. So for instance, you write a textbook, and if you're not publishing it locally, but you publish it internationally, I'm sure you realize that you do not control how these works are distributed. You do not control access to it. It's controlled by the publishers. So if our role within that space is highly limited, if our role within that space is really, constrained, then we need to begin to ask ourselves that even if content is available, what can we really do in the access space? So before I go into deeper content, it's a challenge to the IP framework within Africa. It's a challenge to the industry that makes things happen within the IP frame in Africa, to ensure that we are playing within this circle. Because if we do not play within this circle, the effect we can have globally is then limited. The ability to access these materials will always be there so long as content is being created. But remember, he that plays the piper will dictate the tune. And that's why, for instance, you're thinking of an African work. You write something and then you publish it about Africa, for instance, and it's published, in one of these big fives. It's very likely they will decide if, for instance, it's going to be online. Is it your work that's going to, be fully displayed, going to be made accessible, or is it going to be some other work? But if we play very strong roles within this space, if we're able to build infrastructures that ensures that within the access gate we have a voice, then you will see that our works will begin to manifest, within the system. And now this is not just with the publishing industry. We can look at, moving outside the publishing, we can look at patents and ask ourselves, where is Africa within, the patent filing system? Now, Africa is actually represented. Actually, we're over 20,000, but we're not listed amongst the first 10. And in terms of innovation, in terms of creativity, you see that we are a very rich country. You see that we're a very rich continent, but we need to ask ourselves certain questions. How come we are not playing properly on the map? I'm in Australia. That's a country of about 25 million people, compared with Africa of 1 billion, Nigeria of almost 200 million, and 25 million people are able to have a filing of over 32 you know 32 million. Sorry, 32,000. It should get us thinking that how are we connecting to what is actually available? Because content that is available is what we struggle with in saying, can I have access to it? And we are content creators in Africa. And I'm setting the stage this way by saying it's one thing for us to cry out to say IP is an enabler, is a catalyst for development. Can you give us access to this information? If there is a change in mindset to, we also need to be contributors to the creation of this content so that we can dictate what happens in terms of access, what happens to our content, and we're not sitting in the place of, oh, can we be given access? Can we be given access? Which is really important. I mean, we ride on the shoulder of giants to do whatever it is that we need to do or we want to do. But we need to ascend after a certain time and get to a point where we are creators ourselves, and then we begin to make impacts in ways where permission will be sought from us to get access to our work, because we actually have this content. Now, with that in mind, I would like us to understand that, you see, IP plays an interesting role. The role that IP plays is the role that the initial crafters of this framework thought about. It's a framework that incentivizes creativity, and that's because IP as a legal framework protects the creations of intellect. It protects creativity, it protects innovation. And you will ask yourself, why is it doing so? Because there's a lot of investment that goes into it, and if there is no such investment, then there will be no incentive to create, there will be no incentive to innovate, there will be no incentive to invest. But that's on one side. The other essence of IP is such that which has been created can then translate to a tool that will cause development. And therefore you have two things, which is incentivization of creativity and yet access to what has been created, is access to the content. And therefore, anytime you see an imbalance where incentivization is taking priority over access, then we have a problem. But there needs to be that balance so that the intention and the objective, the dual objective of IP, can actually be properly delivered. What's the challenge? The challenge is that in the incentivization of IP,
it's not a platform that enables us to sit down and beg, but rather a platform that enables us to contribute to the world. If we develop that mentality, then I tell you, in the next 15-20 years we can change. Let's just take our entertainment industry, for example. We have an interesting entertainment industry. We have, in terms of movie, in terms of music, we have an industry that is blossoming. One of the things that Nigerians are known for around the world is our musicians, is our actors, and that's just one area of IP in terms of creativity, entertainment. Now, but there is a lot we can do in the tech industry. I mean, just think of China, for instance, that came up with TikTok. It's gone around the world. I keep thinking, are we saying about 200 million people we can't create, an app that is, created by a Nigerian, and that Nigerians decide to start using, and that can be our contribution to the world? Now, IP enables that if you are investing that money into that software or into the development of the app, you will be able to recoup your investment. So IP contributes to development in a way that enables those who want to contribute to say, all right, if I put in my investment, I'm not going to lose out because there's a framework that protects me. But it also is an interesting infrastructure such that after it's been cooked, you can look for ways to sell to the high and mighty, sell to the ordinary, sell to the ordinary people, and it's also our way to get the global map. It's a wonderful opportunity for anyone who wants to use. Most of all, it's mostly TikTok. I'm going to tell you that we're using technology in China. IP gives us that opportunity to be able to do that, but there's a change of mentality that we are not users. We can be content creators and send that content all over the world. And honestly, some Nigerians are already doing that. But we can do it more, such that when you're looking at the end of the year at the patent filing, at the trademark filing, at the industrial design filing, you can see that Nigeria begins to move up on the ladder. So IP creates an opportunity, but are we using it?
Thank you, sir, for standing in gap for Professor Adam. Do we have any questions from the audience? Okay, in the absence of none, I'll be handing over to Dr. Eli Chuma-Okoro to chair the panel. Hello once again. So we have come to the conclusion of the main presentations, which are more like frameworks. So the next section, we tagged it panel of case studies. Essentially, we want to listen to specific stories. Some of the stories you might wonder what's the connection between this story and this. Like one of the stories is a unique case of justice delivery. Justice delivery is one of the SDGs. And then the question is, what has intellectual property got to do with this? Now we have heard that intellectual property connects with creativity and innovation. And most of this knowledge, creativity and innovation, they are what helps solve a lot of the problems in life, health issues, food, guarantee food, safety, and things like that, livelihood. So at these case studies now, listen to their unique stories. We have 6 case studies. I'm hoping that we'll have all of them able to present. 3 are going to be speaking here with us. 3 are going to be speaking offline. So I will urge the IT people to put their profile one by one. I want to start with Alafia. Alafia, I think you're the first person on that panel. So Alafia, if you don't mind, just have a seat here, please. Please, yeah, thank you. So the next person to tell us a unique story is Olubusola Afolabi. Are you here? Yes. Take a seat. And we also have joining us all the way from Netherlands, we have Dr. Douglas McCarthy. I don't know if okay, before I get Douglas, let me call the next person to join physically here. And
I'm speaking of no other than Miss Linda Alpheus. So, Miss Linda, you're welcome. Please, can you put up their profile as they're coming up? Yes. So, Linda is a director with the Nigerian Copyright Commission, Lagos office. And Olubusola is from the Free Knowledge Africa, also in charge of research, education research, right? Okay, that's you. Okay, we have Alafia, who is the co-founder of Free Knowledge Africa. So Alafia is going to tell us his story about open domain and projects that they have done about open domain and how they have some kind of connection with the SDGs. And Olubusola is going to be talking to us about Creative Commons licenses, while Linda is going to be talking to us about partnerships, how you can also build partnerships, and that way you help the attainment of the SDGs. So that is for the people we have here. So we have our online panelists. I think I called Dr. Douglas earlier. I don't know if he's here with us. Dr. Douglas, are you there? He's here, okay. Dr. Douglas, you're welcome. So Douglas has a unique story to tell us about the project they call Open Land Survey and how that project helps the access to information and knowledge, especially in cultural institutions like libraries. And we have a very good library here. It's an interesting conversation for our librarian here. So we also have online Miss Esther Ngom. Esther, are you here? Esther, are you here?
I'm here.
Okay, Esther, you're welcome. So Esther is going to be telling us about geographical indications and how it has the potential of helping rural development in Cameroon. And then the last but not the least, we have our very own Honorable Comfort Chinyere, and I'm hoping that she'll be able to join us along the line. Presently, she said she's on board, she's on air, so if we cannot really connect, I hope that we'll be able to connect with her as soon as she lands. So that's it for the panel that we have. So I'll go straight on with you, Douglas. And let me remind all the panelists that we have 10 minutes. You have 10 minutes to tell us a story. Sorry, not Douglas. Sorry about that. Alafia, we have you on as the first panelist, right? So let us hear your story.
Good afternoon, everyone. Good afternoon from Nigeria, for those joining us online. This is Alafia Bami, part of the leadership of Free Knowledge Africa, and in 2021, we the leaders at Free Knowledge Africa discovered the importance of the public domain through the works of the members of the Creative Commons, the Creative Commons group in Indonesia, led by Ilman Fatoni at that time. Our interest was piqued, and we were interested in the purpose of the public domain, and we started this public domain digitalization project. So our first step was to identify the works in the public domain. We decided to carry out a contest where we invited multiple young Nigerians. Before the contest, we did an educational video about what are the works in the public domain, how to identify them. For instance, books expire the copyright of books expire 70 years after the death of the author. So we made an interesting video, we made it available on social media, it is currently on our YouTube, and we carried out a contest, and in that contest we were able to document over 1,000 books, over 1,000 creative works in the public domain. So when we realized the voluminous nature of works just through an online survey, we thought about digitizing this work. Then last year we embarked on this journey that is not going to end soon, about what is in the public domain, about books in the public domain in Nigeria, and informing Nigerians about this procedure. So last year we started from the Department of Library Services at the National Library Abuja, and we went there, we advocated about the public domain, we educated the librarians in that department, we had a session with them, and in that procedure we were able to get about 400 works digitized. Those works are currently on Wikimedia Commons, and in the future we plan on expanding it through this website called publicdomain.ng. So publicdomain.ng will be like an online repository of all public domain works, all digitized public domain works. We just got the name, we've not built the website yet, but it is a work in progress. So this procedure is very, very important, and we need to educate more Nigerians about it. So the first step is we want to encourage our librarians, our creative authors, that it is not all your creative work you get your copyright on. Some can be released into the public domain as it has its advantages and it has its disadvantages. While one Bukola is speaking, she's going to mention the essence of releasing works into the open movement, so I don't want to get into that. And as it relates to the SDGs, releasing open educational resources into the public domain can help us solve the issue of, we have this problem in Nigeria where we have about, I think, 15 to 20 million kids are out of school. So if we can use open educational resources, we can have class data banks in different region of Nigeria, and children can go to school at their own free will. The concept of education does not have to be based on the classroom. We can remodel this concept of education and have class monitors or have class data banks, and through the internet educate the regions of Nigeria where there are no schools, and open educational resources give us these opportunities, and documenting items into the public domain also give us this opportunity where anybody in the whole world can use your resources. So that is what I want to say for now, and if there are questions, I would like to improve on it. Thank you.
If we can do better, I know we are tired. Thank you. Alafia, thank you very much for that brief explanation of your own experience. Now, Busola, can we hear from you about Creative Commons?
Thank you. Good day, everybody. I'm here as a member of the Union Advocacy team and also as a member of Creative Commons Government and Creative Commons Nigeria. Now, a lot of people have spoken about IP and public domain, and though what is more prevalent to us in IP is copyright. So we have copyright, we have public domain, which are like on opposite ends of like a line, because public domain simply says there are no rights reserved, like everybody releases your rights, and copyright is all rights reserved. The author owns total right to his or her work. But then there's another concept of some rights reserved. So it doesn't have to be totally closed or totally open. It could be in between, and that's where Creative Commons licenses come. And there is a series of licenses that gives author the right to release their work on certain conditions. You release your work when you use copyright to release your work, you are taking total control to yourself. Like all rights are reserved to you as the author. And when you release your work under the public domain, you are releasing total rights, meaning no rights reserved to you. Everybody can use your work as they see fit. But then you are creating common licenses that kind of bridge the gap between public domain and copyright. Some people refer to public domain as copyleft, just to show you one is at the left hand side, one is at the right hand side, and then we have creative common licenses in between. So I'll just give a rundown on these licenses. There are 6 in number. So the first one is CC BY. That's CC stands for Creative Commons. So BY here stands for attribution. Now attribution simply says you have to credit me as the owner of this work. You know, with public domain, you don't even have to credit me. You know, work that in public domain, they belong to nobody, so you could use it as you see fit. But once I publish my work under CC BY, it means you could use the work as you see fit, and you'll just credit me as the original author. So that's CC BY, which is the least, it's like the least strict license. So it's closer to public domain than copyright, the CC BY. Then the second one is CC BY SA. Okay, the BY there is a constant on all 6 Creative Commons licenses. So for whatever Creative Commons license you choose to use, attribution is a constant. So attribution is always there. So the second one is now CC BY SA, which is attribution share alike. Now share alike comes in the fact that if I am reading license. If you use my work, you can't come and copyright that work. So it's just for like a continuity, to bring about a continuity of the Creative Commons license. So when I share my work under CC BY SA, number 1, you have to attribute me, and number 2, you have to share your work in like or similar manner by which I shared my work. Now the third one is CC BY NC, which is non-commercial. Remember I said BY is a constant, so I'll be saying BY for every license. Now NC is non-commercial, meaning you can use my work, you have to attribute me, which is BY, which is a constant. You can't use my work for any commercial purpose. The moment you use my work and you sell, you're infringing on my rights. Even though I release that work openly, but then there are some conditions you have to go through. There are some conditions you have to fulfill while using my work. So CC BY NC is non-commercial. You can only use the work for non-commercial purposes, like creating for research purposes, for creating open educational resources for teaching or for schools or for anything that is a non-commercial purpose. Now the fourth one is CC BY ND. ND here says non-derivative, meaning you can't change anything about my work. Now if I release a work and I wrote a book in Yoruba language, once you are using my work, you have to use it in Yoruba language. The moment you translate it to English, you have infringed on my copyright. If I have a painting and I did a painting of a dog, and then you want to use, but you want to put that painting on your t-shirts, the moment I painted dog purple color, the moment you change the color of that dog, you've infringed on my copyright. So that's the conditions to non-derivative. You have to use it exactly as it is. The moment you change something about it, you have infringed on my copyright. But if you use it as it is, it's okay, because I released it openly under CC BY and D. So just to remind everyone that BY is a constant. You have to attribute me for every work released under Creative Commons license. You have to attribute the original owner. Now the 5th license is a combination of 2 licenses. That's CC BY NCSA, which is non-commercial share alike, meaning you can use my work, you have to share